I'm A.L.M. Today we are going to deal with warranties and indemnities. Introduction. Warranties and indemnities are available to safeguard the buyer from any difficulties now and later. Without warranties or indemnities, unless the seller has made a misrepresentation in the course of negotiation, the buyer will have no recourse against the seller. Characteristics of warranties. A warranty is a contractual statement or assurance given by the seller to the buyer that a certain state of affairs exists. Warranties are contained in the asset or share purchase agreement and cover most areas of the target or business. They will be drafted by the buyer and will be heavily negotiated. They also aim to allocate risk and liability between the seller and the buyer. Encourage the seller to make disclosures against the warranties. Provide the buyer with a mechanism to adjust the purchase price after completion to what it should have been at completion, or if the parties had known all the relevant facts at that time, and then enable the buyer to seek protection by way of indemnities for known liabilities and or extreme circumstances withdraw from acquisition. Warranties and disclosures by the seller is the disclosure letter served separate but independent purposes. While the warranties are a protection for the buyer, the disclosures work so as to limit the seller's liability under the warranty. Buyer's perspective. Completion of a thorough and due diligence exercise enables the buyer to understand the risk and liabilities involved with the purchase of the target or business. This information gathering phase will highlight the areas where protection against the potential future liabilities should be sought from the seller through warranties and indemnities in the share or asset purchase agreement. This may also influence the consideration paid by the buyer for the target or business. The property warrants a buyer requires will vary according to the level of the due diligence conducted, the nature of the property arrangement, and what the buyer plans to do with the properties following completion. The buyer should insist on some core warranties which cover broad themes. The obvious example is the title of the properties is good and marketable. When disclosures are made against a warranty by the seller, thereby limiting the statement of fact, the buyer should seek to secure an indemnity against any post-completion liabilities on the relevant points. If the buyer wants to enforce a warranty following breach by the seller, it needs to apply to the court. There are post-risk involved in doing so. The remedy for the breach of warranty is damages. Seller's perspective. The seller will usually disclose information against warranties in a disclosure letter. The warranty will then be the fact is a true, serve and disclose. The seller will want the warranties to be specific and targeted as possible to ease their disclosure exercise. The seller will want to limit the scope of the warranties with qualifications as to awareness and knowledge, example using the word so far as the seller is aware. If the buyer has had the opportunity to investigate the title to the properties, or the seller has provided the certificates of title, then the seller may not be prepared to provide many warranties, if at all. Warranties provide the seller with an incentive to reveal relevant information about the properties because information which is disclosed to the buyer cannot form the basis of a claim for breach of the contract. The buyer scope of the property warranties. The buyer will seek to include property warranties in the asset or share purchase agreement which covers the following. The properties have good and marketable title. There are encumbrances affecting the properties. There are no encumbrances affecting the properties. The properties listed in the agreement are the only one used as or required by the target or business. Town or and country planning matters and nothing and other legislation is being complied with. There are no disputes, notice or claims in respect to the properties. The properties are in good repair and condition and are used for permitted use. Landhold properties and properties subject to tenancies. There are no contingent liabilities in respect of properties no longer owned, used or occupied by the target or business. The information contained in any certificate or title is accurate. Breach of warranty. If a warranty is breached, the buyer will be able to claim damages for breach of contract. The aim is to compensate the buyer for their loss of bargain by putting them in a position they would have been in had the warranty been proved. Making a claim for breach of contract on the basis of a warranty is untrue is not straightforward. The buyer will need to prove that a particular warranty is untrue and that the contract has been breached. They have sufficient loss or damage. The loss was caused by the breach. The loss is too remote. That is, the loss suffered was reasonably foreseeable from the breach in question, and they have taken reasonable steps to mitigate the loss. Expert evidence may be needed to support the valuation or damages claim. Sometimes the purchase agreement will include a formula setting out the damages should be calculated, perhaps a pound for pound adjustment or a multiple of any shortfall. In respect of asset purchase transactions, damages for breach of warranty are usually the market value of the business had the warranty been true, less the actual market value. In respect of share purchase transactions, the usual measure of damage will be the deviation of the target shares as a result of the breach, which may well be less than the value of the liability in question. Indeed, it is often difficult to show that the value of the target share has actually decreased as a result of the warranty being untrue at all. In such cases, the buyer will be unable to prove that they have suffered the loss and will not be able to make a claim under the warranties. Seller's protection and disclosure. In addition to the practical completion of making and proving a claim, the seller is likely to have negotiated a suit of other contractual protection which will remove or restrict their liability in certain circumstances. These limitations undermine the power of warranty as a mechanism for legal redress. The most obvious example of this protection will be the financial limitation which is commonly imposed, a cap on the maximum overall liability of the seller, minimize value of any individual claim which may be reached before any liabilities arise, and a threshold, a basket, which represents an aggregate minimum value of all valid claims which may be reached before any claim can be lodged. The seller is likely to demand a broad range of additional limitations and protections. With limitations applied will depend on the negotiating position of the parties. Characteristics of indemnities. An indemnity is an agreement by the seller reimburse the buyer for losses arising from a specific event. The sellers may give indemnities for specific costs or losses that the buyer incurs. Indemnities are usually where there is an unquantifiable risk of a claim and it is difficult to make a price adjustment to reflect the risk accurately. Example, in the case of contingent liability. Characteristics of indemnities include they may have thresholds both individually and collectively. That is, costs are not recoverable unless they exceed sterling X under particular indemnity and or sterling Y in aggregate. They may also be kept along the same line. They are not limited by disclosure. They are a way of reallocating costs, whereas the warranties are a way of reallocating risk. Thank you.